Welcome to this explainer. Today, we're jumping straight into a totally fascinating legal and philosophical puzzle buried right within Dr. Chen Jingyuan's defense documents. Now, Dr. Chen was charged with the crime of spreading rumors, specifically under the umbrella of picking quarrels and provoking trouble. But here's the thing. Instead of just accepting the charge, he mounted a defense that literally strikes at the core of how we define truth, expression, and the absolute limits of the law. We're going to impartially break down the source analysis of this defense because honestly, it has some massive implications for how we all live and share information in the digital age.
So let's dive into the fundamental question sitting at the very heart of the case against Dr. Chen. Before we even look at a single thing he posted, we have to figure out what actually is a rumor in the eyes of the law. Is it just something the authorities happen to disagree with? Or is there a much stricter, more scientific legal standard at play here? To unpack this incredibly complex intersection of law and human expression, we'll be following a structured six-part roadmap drawn directly from the source documents. We've got 1, defining a legal rumor, 2, art and human emotion, 3, academic and theoretical views, 4, historical and factual data, 5, the burden of proof, and finally, 6, the systemic impact on knowledge. Okay, starting right off with Section 1, defining a legal rumor, the core legal framework. The absolute crucial point here, based on the interpretations from the Supreme People's Court and prosecutorate, is that for something to legally be considered a rumor or fake information, it absolutely must be an objective, factual statement that is capable of being proven true or false. It has to exist in the realm of verifiable reality. It can't just be an opinion. It can't be a vibe. It needs to have a binary truth value, meaning it is either factually true or it is factually false. And this is where we see Dr. Chen's defense strategy, which is honestly pretty brilliant. Instead of getting bogged down arguing about his internet posts one by one, he meticulously categorized all of his forwarded posts into 4 distinct buckets to test their legal validity. He sorted them into artworks, subjective emotional expressions, academic theory, and objective historical descriptions. By doing this, he basically forced the legal system to evaluate the actual nature of the expression itself, rather than just the raw content. Moving into Section 2, art and human emotion, the boundary of expression.
Looking at those first 2 buckets, art and human emotion, the source analysis draws a really stark contrast. On one side, you have fact statements. These are things that can be verified. On the flip side, you have value judgments and emotional expressions. The documents point out that artistic metaphors, like maybe a satirical cartoon, or emotional posts, like sharing a picture of a candlelight vigil or just expressing grief, fundamentally lack a true or false attribute. You literally cannot put a satirical cartoon or a feeling of sadness under a legal microscope and declare it legally fake. The math just doesn't work.
Now, what's super fascinating here is how the source material applies high-level philosophy directly to criminal law. They bring in the philosopher Gilbert Ryle's concept of a category mistake. The argument is that labeling art or human emotion as fake information is a textbook philosophical category mistake. You're attempting to measure subjective human feelings with an objective legal ruler. It's kind of like asking a judge if the color blue is legally true or false. It makes zero logical sense, and according to the analysis, it falls completely outside the bounds of what criminal law should even be looking at. Which brings us to Section 3, academic and theoretical views, the realm of thought. The analysis makes a really sharp distinction here by comparing an actual criminal act with cognitive activities. A criminal act of spreading a rumor is an external action, right? It's meant to cause public disruption. But academic research, analyzing ideologies, comparing different social theories, these are internal, cognitive activities. Ideological debates and scientific theories are interpretive by their very nature. They aren't binary facts that you can just criminalize as rumors. And this leads to one of the most intense arguments in the whole defense. The prosecution apparently used Dr. Chen's private viewing records, literally what he watched on YouTube or searched for on Google, as evidence of his crime. The source documents strongly argue that using a person's internet viewing history as evidence of a rumor crosses a massive, neon-flashing red line. It shifts the law from punishing a harmful action to punishing thought and academic curiosity itself. Just imagine your private Google searches suddenly being used as proof of a crime just because you wanted to learn about a controversial topic. It treats the simple act of paying attention to certain knowledge as a criminal offense. That takes us to Section 4, historical and factual data, the reality of evidence. Now, this 4th category, historical and factual data, actually does fall into the realm of things that can be proven true or false.
But what happens with posts discussing historical events or, say, sharing a screenshot of a payslip? Well, the defense argues that simply declaring historical documents or data as rumors without formal authentication skips a completely mandatory legal step. You can't just administratively slap a fake label on historical data. It requires strict, expert authentication, actual data verification, and proper legal evidence to definitively prove it false.
On top of that, the source makes a super clear distinction about who is actually responsible. If a piece of factual data on the internet is indeed false, the legal liability should fall squarely on the original fabricator, the person who intentionally created the lie in the first place. It should not fall on an everyday forwarder like Dr. Chen. Think about it. The law doesn't expect you to have a private investigator on retainer to verify the absolute truth of every single meme or article you retweet. Regular citizens operating under a mistake of fact simply don't have the investigative resources or the legal duty to independently verify the absolute truth of every single post they share.
Right, let's look at Section 5, the burden of proof, the procedural mandate. To legally convict someone of the specific crime, the prosecution can't just rely on assumptions or vibes. They must definitively establish this chain of 3 sequential steps. First, prove with hard evidence that the information is demonstrably false. Second, prove the defendant actually knew it was false and spread it anyway, what legal folks call mens rea or criminal intent. And third, prove that this action directly caused severe public disruption. But when you look at the breakdown in the defense's analysis, they argue the prosecution struck out on all 3 fronts. There was no expert authentication of falsity provided, there was 0 proof Dr. Chen knew the forwarded posts were false, and regarding severe disruption, the data showed Dr. Chen had fewer than 100 followers and his posts had virtually 0 engagement. I mean, how can there be severe societal disruption when almost no one even saw the posts? The source material argues that the state basically reversed the burden of proof here, asking the defendant to prove his innocence rather than fulfilling their basic legal duty to prove his guilt.
And finally, Section 6, Systemic Impact on Knowledge, the Macro Philosophy.
Drawing heavily on the philosopher of science Karl Popper, the source documents issue this profound warning. Because all human knowledge, and yes, that includes modern scientific theories like relativity and quantum mechanics, is subject to revision and inherently contains flaws, demanding absolute truth under the threat of criminal penalty effectively halts intellectual progress in its tracks. If a disputed theoretical article can just be criminalized as a rumor, then quite literally any academic viewpoint could potentially lead to criminal charges. The overarching danger highlighted here is massively systemic. The documents argue that erasing the line between a factual claim and an artistic, emotional, or theoretical expression fundamentally destroys the entire classification system upon which human knowledge relies. It leads to the defactualization of legal language, where words just lose their meaning entirely. It collapses semantic boundaries, institutionalizes cognitive bias, and, perhaps most terrifyingly of all, transforms the legal system from a behavioral law that punishes actual harmful actions into an attitude law that punishes undesirable thoughts and feelings. As we wrap up this explainer, we want to leave you with this really profound question to chew on. Based on the deep analysis of Dr. Chen Jingyuan's defense documents, we all have to ask ourselves, where exactly should the law draw the line between a factual, genuinely harmful rumor and the natural expressions of human emotion, art, and intellectual thought? Understanding and protecting these boundaries is absolutely crucial for the pursuit of knowledge in our digital world. Thank you so much for joining me to unpack this. Keep questioning and keep learning.